All right, let's proceed. Good morning.
Good morning, Your Honors. May it please the Court. I'm John Ertman from Ropes & Gray on behalf of the appellant funds. Your Honors, if I may, I'd like to very quickly clarify at the outset what this case is about and what it isn't about. This case, as pled by Brigade and presented to the Court by both parties, is strictly a contract case. Whether the fund's Board of Trustees had the authority to set the fund's annual shareholders meeting for July 31st, 2012, under the fund's bylaws, because that date was within the fund's fiscal year. And I can tell you, Your Honors, that it's a matter of public record that, in fact, the annual meeting did take place on July 31st, 2012, and Brigade's nominee did win a seat on the board. It won one of 7 seats on the Board of Trustees. I could, well, and just to clarify, of the 7 board seats, 2 of them are designated as ARP seats. That is, that only preferred shareholders, ARPS holders like Brigade can vote for them. And so Brigade's nominee won one of the 2 ARP seats. And I can also tell you, it's a matter of public record, that the next annual meeting has been noticed and is scheduled for July 31st, 2013. So it's coming up soon. And Brigade has noticed that it intends to run another nominee for the board for the second ARP seat, which is becoming vacant at this next upcoming annual meeting.
Well, Mr. Ertman, when we say something is going to be held on an annual basis, does that mean within every 12 months?
Your Honor, it means on an annual basis, both sides agree, it means once during a 12-month period. Okay? Both sides said that the bylaws were unambiguous, and each side presented what they believed was the 12-month period. The funds believed it's once during each fiscal year because that is the only reason that the funds have an annual meeting at all. These are Massachusetts business trusts. There's no requirement under federal or state law that they have an annual meeting. The only reason they have one is because the common shares are listed on the New York Stock Exchange.
Well, they have it because the contract provides for it.
The contract does provide for it.
And why ever it does that is kind of beside the point, isn't it? I mean, they have it because they have it.
Yes, that is true. And the question here is, when do they have to have it? Okay.
Why, if as you say, it has to be, your position is once every fiscal year, and the fiscal year, I take it, goes August 1 to July 31? Is that
yes.
Right? But you have a history of having had it in December. So why the switch?
That's true. Well, Your Honor, a couple things. Okay. First of all, that the bylaws themselves, this has strictly been presented as to what the bylaws mean, and the bylaws themselves, as 2 of the 3 judges below hearing this have agreed, the bylaws give the board the flexibility to set it once during each fiscal year in accordance with the NYSE rule, which is the only reason we're having the meeting to begin with. Now, what this case is not about, it's about the motives, the reasons, the purposes of why the board in this case chose July 31st. Okay, that's an important point because right at the outset of this case, Brigade demanded sweeping discovery of the trustees, of wanting to know what the reasons were. And the initial judge in this case, Judge Fabricant, ruled no, that the motives, the reasons, the purposes were all entirely irrelevant to
Do we need to go there to construe the contract that is before us? I mean, do we even need to know what the different judges did in construing it? I mean, isn't this presented to us as a question for us to construe?
Yes, it is, Your Honor.
So all of that is really sort of an irrelevancy as to what this contract language means.
I think that their determination is helpful.
Well, it may be helpful, but whether or not there was discovery or not discovery or motives and so forth, isn't that sort of an irrelevancy as to determining what the language at issue means within the context of this document?
Yes, we would agree. I'd agree completely that you look at the language of the document.
And when you say that, it's there because of the stock exchange, if you withdrew from the stock exchange, you would still have this meeting requirement unless and until the contract was amended.
No, that's not correct.
It's not correct that you wouldn't have to amend you wouldn't have to amend this?
The language of the contract says as long as we are a member of the stock exchange.
Yes, Your Honor. The only reason we have a meeting is so long as the common shares are listed on the NYSE, and that's a critical point. Judge Laureate below ignored that critical language. He has a one-sentence footnote that says, well, the NYSE is just a private organization that's irrelevant to the bylaws. But respectfully, that's not correct. As Justice Milkey recognized in granting a stay of the judgment we're appealing from today.
But we're just trying to,
Yes.
I mean, basically, I think everybody's agreeing. We're trying to construe what the language means.
Yes.
So it either means what Judge Milkey says it means, or it means what Judge Lauria said. But I mean, you can't say as a matter of law the fact that it says as long as we are members of the New York Stock Exchange, we will have an annual meeting means that necessarily I mean, you argue that, but it's not written in stone that clause translates into fiscal year is the only thing that matters.
Yeah, it's certainly relevant to the analysis. It's not the only part of the analysis,
Right.
because the basic principle of contractual construction, as you all know, is you look at the bylaws as a whole. You also have to look at Section 10.6C, which is another critical provision that Judge Lauria ignored in the judgment below. In 10.6C, this is the provision that expressly says that the board can set an annual meeting here for greater than 13 months after the prior year's meeting. Section 10.6C is the provision in the bylaws that deals with when a shareholder has to give notice if they're going to nominate a candidate at the annual meeting to run for the board. The timing requirements for giving notice vary slightly depending on when the board chooses to set the annual meeting. Section 10.6C says that if the board chooses to set the annual meeting in a period within 11 to 13 months after the prior year's meeting, you have one timing requirement for a shareholder to give notice that they're going to put somebody up for the board. If, however, 10.6C goes on to say that the board determines to set the annual meeting at a time more than 13 months after the prior year's meeting or less than 11, that there's a different timing requirement.
Doesn't that really, though, going back to 10.2, it suggests that there are two different kinds of meetings. There's the regular meeting, which would be on at least an annual basis, but in the event that it's not held in any annual period, whether by oversight or otherwise, then there'd be a subsequent special meeting. And couldn't you read the language that you've just been citing as, you know, dealing with essentially those two different kinds of situations? So that it's within 13 months because they're, you know, by omission or otherwise, by oversight or otherwise, the annual meeting didn't happen within that 12-month period.
No. No, the language that's used in 10.6, respectfully, Your Honor, the language that's used in 10.6C deals with annual meetings, when the board sets the annual meeting. That is the term. There is no question that that term applies to an annual meeting like the type we're doing here today. Now, Brigade has a long, convoluted argument that points out that in 10.6, annual meeting could mean a regular annual meeting like we're talking about and what's called a special meeting in lieu of an annual meeting. That's an extraordinary event where, for whatever reason, the scheduled annual meeting couldn't take place because of, for example, force majeure, there's a tornado, and that you would schedule a special meeting in lieu of annual meeting. And so what 10.6C says, it talks about annual meetings. It could mean regular annual meetings as well as special meetings in lieu of annual meetings, but there is no way you can construe 10.6C to mean that it only applies to special meetings in lieu of annual meetings. Under the plain language of 10.6C, it clearly is talking about a regular annual meeting like we have in this case.
Now, if you are right and if you win, could you hold your next annual meeting on July 31 and then follow it up on August 1 with the annual meeting for the next year?
Right. This, as I understand the question, Justice Gantz, this is going to Judge Lauriette's pretty much driving rationale here that if fiscal year is the correct interpretation of the bylaws, that you have a possibility of multi-year shenanigans, that you could hold the next annual meeting immediately in year 2 after the year 1. Year 3, you can have it long afterwards. Okay, that scenario is not this case. Okay?
I know, but,
in fact,
try my question.
Right.
If you're right, could that be done?
Yeah, hypothetically, in a hypothetical world, it could be done. It also, under the NYSE rule itself, it could be done. But with the multitude of listed companies on the NYSE, we've never heard of that happening in real life. Okay, it's just not a real-world scenario.
Would there be any recourse on the part of a shareholder if you tried to pull that?
Yes, absolutely.
And what's the recourse?
There is recourse because you could attempt to bring a fiduciary duty claim where you can argue that the board was acting contrary to the interests of the funds in breach of its fiduciary duty of loyalty, in which case you would have to show that under all the circumstances, taking into account all the factual circumstances, that the reasons for scheduling those meetings were not legitimate. The board didn't have a legitimate reason. It had an improper intent, and it actually caused improper harm. Okay, that's a fact-intensive claim that's not part of this case at all. And in fact, a Brigade at the very outset, when Judge Fabricant denied them discovery into the motives, reasons, and intents of this case, they said, okay, we want to amend our complaint, bring a fiduciary duty claim, name all the trustees as individual defendants, and then get that kind of discovery. Judge Fabricant gave them leave to do that, and for whatever reason, they chose not to do that. Instead, they immediately moved for summary judgment at the same time as the funds did on their contract claim, which strictly is what the bylaws mean, and so both sides saying that it's unambiguous contract under the plain language. They're saying that the board is straitjacketed and must hold annual meetings no more than 12 months after the prior one, which, as I mentioned, is totally inconsistent and contradicted by 10.2 and 10C.
Can I ask you this? You say that the NYSE has fiscal year that has to be.
Yes, it does.
I don't know where that is writ, but wherever it's written, does it use the word fiscal year?
Yes, it does. Once during each fiscal year, yes.
Okay, and so why didn't the funds? I mean, if that's what they meant, why didn't they write that?
Yeah, you're right. Bylaws could be drafted better, but I know, as Justice Milky mentioned below, the fact that the term fiscal year isn't there, it doesn't mean fiscal year. I mean, we have a case where we have two proffered explanations of what on an annual basis is, what that period is, and when you construe the bylaws as a whole, ours makes sense. Okay, theirs can't make sense, okay, because theirs is directly contradicted by 10.2 and 10.6C.
Well, it's not. It's derivatively. I mean, it's certainly not directly contradicted by 10.2.
Yeah, well, I would say yes when you take into account that the only reason we're having it, the funds are having an annual meeting at all is because of the NYSE listing, and it certainly is. Their interpretation is contradicted by 10.6C, which expressly says the board can set a meeting 13 months or more after the prior year's meeting.
I take it the reason you're pressing this, there may be reasons why we want to reach it, but you're pressing it, it's moved for you, right?
The immediate controversy of the parties, yes, it's all about that July 31st, 2012 date, okay? That date happened, and there has been no disenfranchisement, no keeping anyone off the board. Brigade's nominee got elected, okay? Our position is we are here because we have what we believe is an erroneous decision by the Superior Court below that says that the board violated its own bylaws. Okay, that's a very serious thing. You know, the board has to act in the best interest of the funds as a whole, and they do not want a decision like that to stand because they genuinely believe, construing the bylaws as a whole, that they did the right thing. They did it with what the bylaws permitted, and that the judgment below should be reversed. Okay, as to why Brigade is pressing here, they have to speak to that. I could say that the only motive of any of the parties in the record is Brigade's motive, which is they've been very public about. They actually don't want to be on the board here. They don't want to be ARPS holders. They just want the effect to buy out.
At 100 cents on the dollar.
What's that? At 100 cents on the dollar. That is what they want to do. They have no entitlement to that. And because that didn't happen, we are now they have engaged the funds in long, protracted litigation. We're now at the third level of the Massachusetts judiciary, and at bottom, from the fund's point of view, this is just a pressure tactic. It's using litigation improperly to reach an arbitrage outcome.
All right, thank you, sir.
Okay, thank you. For Brigade's other arguments, I'll rest on our pleadings and the opinion of Justice Milky below. Thank you.
May I proceed?
Yes.
Chief Justice, Associate Justices, cases like this just don't come around all that often. When you have an opportunity to make absolutely crystal clear corporate law, which will have an impact not only on this case, and let me make it clear, we do want to be on the board. We're in the same business they're in, the business of trying to make money for our investors. There's nothing wrong with that. And, you know, the notion that there was no harm, no foul here, we were delayed 6 months. Every single day during those 6 months, the world was changing, decisions were being made. As Judge Turo said in the ER Holdings case from the federal court, delay is deadly when you're talking about shareholder rights. This case is an extreme example where corporate bylaws, the plain meaning, has been tortured beyond belief. Only lawyers could argue that the words annual basis, which appear 3 times in 10.2 in the first 2 sentences, really mean fiscal year. Well, there are other places in the bylaw, Your Honors, where the drafters use the term fiscal year.
So-
We cite that. I'm sorry, Your Honor.
No, I didn't mean to interrupt you. Are you going to turn to why 10.6 doesn't suggest maybe it does mean fiscal year?
So it's not even a close call. 10.6 is a notice provision. These provisions are put in there solely to make it harder for an insurgent to exercise their right to run a candidate. It's a notice provision, full stop. All 10.6 says is that when you're dealing with a special meeting in lieu of an annual meeting or a regular annual meeting, and it collapses those 2 terms and defines it as annual, it gives you a notice regime. Bottom line on 10.6, if you're in the normal notice period, you have a 15-day window. God forbid you miss it, you're not going to get a nominee. But if for whatever reason they hold the meeting earlier than 11 months, well, then you have to adjust the notice. You got to get the notice out there earlier. If they hold it after 13 months, then they give you a different notice regime. But to take a notice provision and to say that it overrules the crystal clear plain language of 10.2, and by the way, the notion that somehow the New York Stock Exchange rule has been incorporated, if you want to incorporate something, corporate lawyers know how to do it, and it's done in this bylaws and other places. The plain language, and I'm not the world's best grammarian, I didn't do that well in school in grammar, all the so long as listed on the New York Stock Exchange does is tell you for how long you have a requirement to have an annual meeting. They didn't have to have one on the trust law of this Commonwealth. They decided in their certificate that they would hold annual meetings. They said, we'll do it the way the bylaw says we'll do it. You turn to the bylaw, 10.2, that's what we did. And the bylaw says they will hold annual meetings for the election of directors on a regular basis, on at least an annual basis, as long as they're listed on the New York Stock Exchange. It doesn't tell you we're adopting the New York Stock Exchange rule. By the way, as Professor Freed in the amicus brief pointed out, and Your Honor, Justice Botsford asked the question, it's at Joint Appendix 952. It's really funny. Their whole case rests on this slender reed of an incorporation of the New York Stock Exchange rule. Look at the rule. It's in the appendix. First of all, the New York Stock Exchange uses the words annual. They don't say hold a meeting once a fiscal year. It says hold annual shareholder meetings. Plain meaning of annual is within a 12-month period occurring. But this is my favorite. Look at the lead-in language to the New York Stock Exchange rule, which they say is their chief litmus test. The lead-in language says, consistent with the exchange's longstanding commitment to encourage high standards of corporate democracy, every listed company is expected to follow certain procedures aimed at maintaining appropriate standards of corporate responsibility, integrity, and accountability to shareholders. Does anyone here believe that delaying an annual meeting with no notice, no reason whatsoever, and by the way, it is on the record at Appendix 1264, my colleague was asked, is there any reason why this meeting was delayed, other than the obvious reason? He said, well, that hasn't been developed on the record. Your Honors can look at that. But the notion that we're using the New York Stock Exchange rule as the basis, Your Honors, for this really perversion of the plain meaning is quite extraordinary. More importantly.
So let's assume you prevail.
Yes.
The annual meeting this year is going to be held on July 31st. When must the next meeting be held?
Who knows? We'll have to wait till PIMCO.
No, let's assume you win.
Well, if we win, we don't get control. All we're getting is another seat.
Okay, but what are the contours? If the language is, as you say, an annual basis, when must that next meeting be?
Within the 12-month period after the annual meeting this year.
So it could
Full
be,
stop.
So it could be August 1st.
We won't complain if they want to move up shareholder rights and give us a chance to vote again. There's nothing wrong with that.
So basically the same issue may arise if you prevail, that they could say it's July 31st and then we'll hold it the next day. That's within the calendar year?
They could do that, and then they could wait 23 months
No, they couldn't.
and 29 days till the next meeting.
Under your interpretation?
No.
No,
You
not
say
under our
every 12
interpretation.
you
That's
say
what I'm
every
asking
12
you.
months.
Let's assume that you prevail.
It's on at least an annual basis.
Okay,
They
and
have
so
to
that's what I'm
hold-
trying to figure out. Let's assume you win. Imagine that possibility.
I'm hoping.
Oh,
Hope
July
springs eternal.
31st, 2013, they hold the meeting. Can they hold the meeting under your interpretation on August 1, the next one? That's within the next, would that be?
Yes, it's within the next fiscal year, and it's within a 12-month period, so it's at least on an annual basis.
So then they would have to hold the next one before August 1st of 2015, right?
Yes, at least on an annual basis.
All right, so, and if they were to hold it on, August 1st, 2015, which would be a year and a day, then you would say they'd be in violation.
If it's more than 1 year from the last annual meeting, we would say that violates the plain language of 10.2. Now, clearly, there may be some play in the joints here, and I doubt we would have been here in a lawsuit if there was a 3-week or a 2-week, extension. Here, we're talking about 7 months.
But how are we to interpret, this is your contract, how are we to interpret the play in the joints?
Okay, that's a fair question. First of all, it's not my contract, and that's what I would ask the court to take the opportunity to adopt the law of Delaware that's cited in the air gas case, that's really law across this land, that corporate bylaws, if there is an ambiguity, as Justice Gantz perhaps is suggesting, it's interpreted against the drafter. We're not the drafter of this contract. Number two, the case law throughout this land is uniform. Where there's an ambiguity involving shareholder rights, the right to vote, which is the only right we have, that it be interpreted to protect that right. And I think this is a vehicle for making those 2 points, Justice Gantz.
Let me follow up on Justice Gantz's question, because I think I understand that Justice Laureate's decision was actually contrary to what both parties were saying. Didn't he effectively say that the annual meetings have to occur nearly approximately 365 days apart?
It's funny, in his opinion, he used the word approximately, but when you go to his order, that was actually the order granting summary judgment, the word approximately does not appear.
Yeah,
Justice.
but getting back to my question, didn't he, in his opinion, say that the annual meetings should be nearly approximately, or should be approximately 365 days apart?
I think that's a fair summary, and the air gas.
But that's not what you just said in your answer to Justice
Because
Gantz.
we believe the bylaws are clear. The bylaws set up a standard, and the plain meaning of that standard, I think, is plain. The meeting has to be within a 12-month period. That's the dictionary definition. And by the way, it uses the words annual basis 3 times. I don't know any other way to interpret annual basis.
Well, you interpret as Justice Laureate did, as Judge Laureate did. The annual basis meets once a year, meaning once every 12 months.
Every
we agree with that. It
365, there has to be 365 days between meetings,
Or close to it.
or close to
Well, again, I wouldn't say as a matter of corporate law, it has to be necessarily 365 days or close to it. A company, I think they have the right to move the meeting earlier, but certainly they don't have the right to move the meeting later. In other words, 10.2 actually tells you, but this is not a mystery. The first sentence says, here's how we're going to do it on a regular basis for the election of directors. Do it within an annual basis, within 12 months. It goes on to say, if you don't, then you can call a special meeting.
To tell us why, as a practical matter, Justice Laureate or Judge Laureate was wrong. Why should there be? Why should you be able to have the meeting, as you answered to Justice Gantz? You could have one annual meeting on July 1st of 2013, and then the next annual meeting, or July 31st of August 2013, and the next annual meeting on August 1st of 2013.
I'm not arguing for that position, and if it seems that if I am, I want to make it clear. We think the better corporate practice of corporate governance is to have it, as Justice Laureate said, every 12 months. That's the way virtually everyone does it, except when there's a reason to delay it. I'm not arguing to have a meeting on the 364th day after the last meeting, and then to have the next year's meeting, 367 days, a day or two into the next 12-month period.
Doesn't it say that it has to be at least?
Yes.
So you could have multiple annual meetings within the course of a 12-month period?
No, I think for the election of shareholders, you have to have one annual meeting at least on an annual basis, at least. So the outer boundary, as I read the plain language, is the 12-month period. I mean, it's really remarkable. The bylaws do not say the outer boundary is the fiscal year. The bylaws use the term fiscal year at least 3 times that we cite to in our papers. 3 times those words are used, fiscal year. They do not appear in 10.2. If there's any ambiguity in this bylaw, it has to be interpreted against the drafters.
When does a newly elected director or trustees, directors, term start? Does it start the day after the election, or does it start on December 1st of any given year?
No, as I understand it, it starts like in all corporations. I don't think it's different here. It's a trust. It starts the day of after the annual meeting when they're elected and the results are certified from the election.
Regarding the New York Stock Exchange, now I understand you take the position that that's irrelevant, but is there evidence in the record as to the frequency of the scheduling of meetings under New York Stock Exchange policy?
Again, I don't.
Year versus annual?
Again, I don't believe it's irrelevant. It tells you when they have to. It tells you that they must have an obligation to have annual meetings. If they weren't listed, then they wouldn't have to have an annual meeting. It just doesn't tell you the timing of it. And the only thing in the record are the amicus briefs. There are 3 amicus briefs, Your Honor, submitted. CalPERS is the largest pension fund investor in this country. That's the pension fund from California. They put in an amicus brief saying that they don't believe PIMCO's interpretation is consistent with general notions of corporate law, annual, and how companies should conduct themselves. Professor Fried from Harvard put in a brief. I'd ask you to read the first 10 pages. It's an eye-opener as to how PIMCO and the mutual fund industry works. They rely on this trust statute on Massachusetts. Most of the closed-end mutual funds, many of them, I think he says 30, 40%, are formed under this Commonwealth's laws. And really, you have precious few rights as a shareholder. And then third, we have an amicus brief from the Council of Institutional Investors, which represents, it's a not-for-profit. And they also say that what occurred here is not consistent with their understanding of how mutual funds and corporations should operate. How many amicus briefs were supported, came in for the notion that annual means once every 19 months? None. And this notion, I don't think mudslinging is the way this case should be decided. This is an opportunity for the court. We're in the same business. Brigade wants to make money for its investors, so does PIMCO. We have a point of view. We're entitled to express the point of view. He brought in the election. We were elected by over 90% of the preferred stockholders, and it was recommended by Institutional Shareholder Services, an independent reporting service, that people vote for us. The fact that that vote was delayed for 6-7 months without any reason is important. And I would suggest to the court, and I think one of the justices asked this question, well, it really doesn't matter. Another way this court could go is the implied covenant of good faith and fair dealing. It is a contract. So if it is a contract, who gets to win if it's a tie or a close call? Shareholders. If it is a contract, who wins if it's an issue of shareholder rights? Shareholders. And isn't there an implied covenant that you have to act reasonably? Well, it's never going to happen again. I'm sorry, Your Honor.
Well, I mean, I think it's where you started. It's a question of interpreting the contract. I don't think it gets into implied covenants here.
Well, I would leave that to the court, Your Honor. I agree. It is a question of interpreting the contract. But I don't think this court, like a trial court, is required to leave common sense at the courthouse steps.
Now, am I correct that the relief you're seeking is purely declaratory at this stage?
Absolutely, Your Honor. And in fact, we won below. I'm the appellee. I won. They're the ones seeking to reverse the decision below.
But you would not be seeking to undo anything with regard to the past meetings. This is merely looking forward.
No, that is absolutely correct, Justice Gantz. The meeting has occurred. We've been elected. And I want to thank this court for the opportunity of taking this case and admitting me pro hac and giving me the opportunity to be heard. Thank you.
Thank you, Counsel.